Hi folks, Denise Howell here, and next up on This Week in Law, we've got death, taxes, patent reform, and sounding off on the internet. Now, who would do that? German prostitution comes in as well, next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 128, recorded September 9, 2011. Sex, Death, and Taxes. This episode of This Week in Law is brought to you by Netflix. Watch thousands of TV episodes and movies on your PC, Mac, iPad, iPhone, or TV instantly, all streamed directly to you, saving you time, money, and hassle. For your free 30-day trial, go to netflix.com/twit. Hello and welcome back to This Week in Law. I'm Denise Howell, and we've got a great show for you today with all kinds of interesting topics that have been going on this week at the intersection of technology and law. And we've got a fantastic panel to go deep on all those topics. Joining us for the first time on TWiL is Kelly Phillips-Erb. Hi, Kelly.
Hi, Denise.
Great to have you. Kelly's the tax girl. She writes for Forbes. And since we've talked about internet taxes on TWiL a number of times, and there have been some interesting developments just in the last day or so, we're thrilled to have Kelly on the show to bring us up to speed there. Thanks for joining us, Kelly.
Thanks for having me.
Also joining us for the first time is Travis Crabtree from eMedia Law. He's a lawyer down in Houston, Texas. Hi, Travis.
Hi there. Thanks for having me.
Wonderful to have you on as well. And joining us once again from Chicago is Evan Brown at internetcases.com. Hi, Evan.
Hi, Denise. Happy Friday to you.
Happy Friday to you. Wonderful to see you again.
The same.
So since we're bound to talk about death, taxes, and patent reform on this particular episode of TWiL, let's start with, I don't know, maybe the least gloomy of the three, the taxes part. Since there has been some back and forth between Amazon and the state of California about their internet sales tax law, and it sounds like that may be coming to a head and or conclusion. Kelly, can you bring us up to speed?
Yeah, the rumor is, because it actually hasn't been confirmed, even though it's been widely reported, that Amazon and the state of California have reached a deal where California is going to choose not to or opt not to enforce the statute that they passed that would require Amazon to collect sales tax for just a year. It's a year moratorium, basically, in exchange for Amazon dropping their efforts to repeal the law entirely. It's been a kind of an interesting 24 hours because the deal has to be wrapped up today under California law, or it's not going to go into effect or even be discussed until 2012.
So just let's step back and give a little background on this whole internet sales tax thing. Way back in the 90s, there were some policy decisions made that internet businesses, online businesses, shouldn't be subject to the regular sales tax collection procedures. There was actually a case, I think, in 1992. Am I right, Kelly?
There's been a couple of cases, but the one you're probably referring to is TWiL. It's the whole discussion about Nexus. And in the 90s, the reason that it was kind of a big deal is because, eBay and Amazon and the online retailers really started coming around in the mid-90s, and California wanted to keep them. And so California and some of the other tech states were willing to kind of look the other way on the sales tax issue, but not everybody was. And so there was a case that went to court. It's very reminiscent of, if you remember back to law school, the whole Bloomies by mail order catalogs kind of brought up the same kinds of issues as the internet sales tax debate. And I think at the time there was a lot of public sentiment that supported online retailers. And so not only did the courts back up the idea that there there wasn't enough nexus, there wasn't sufficient presence to impose a tax. But public sentiment was kind of in their favor. And all that's changed as internet sales have become the norm rather than the exception.
Right. Coffee Chiller in IRC is saying he lives in New York and taxes are not his friend, assuming Coffee Chiller is a him. Sorry if you're actually a she. And here in California, too, I mean, we've got just completely really through the roof sales taxes as well, even though they recently came down a bit. So nobody's a big fan of having to pay more, obviously. Amazon's not a fan of having to collect them. And in fact, California is one of the states where Amazon got in touch with all of its affiliates and said, I'm sorry, but we cannot work with you anymore because of this issue of nexus. As Kelly said, we can't have anything that makes it look like we have workers in the state. And that's an issue with affiliates. And so we've got California going through that, I believe. Wasn't Colorado also in the mix there for a while?
But the big states, actually, that have kind of been loud have been New York, North Carolina, and California. Those are kind of the big affiliate states. And then there's also been issues around warehouses and distributors in South Carolina and Texas. Because Amazon also takes the position that just having a warehouse or a distribution center doesn't or shouldn't subject them to nexus. So, they're kind of redefining physical presence in a way that the courts and the legislatures haven't really sorted out yet.
Right. So, you can either feel that online businesses have now arrived as Tim O'Reilly, a huge hitter in the technology world, writer, publisher, presenter of large conferences, has written a post on Google Plus that we've got a link to in our show notes at delicious.com/thisweekinlaw/128 that basically says now that online commerce is becoming the dominant model in many industries, it's almost criminal to continue to provide that advantage. What do you think, Travis? Is it time for the states to start treating online companies differently, and is Amazon and the other big retailers just going to have to suck it up finally?
It's an interesting dispute they're having right now. Part of the problem, it doesn't necessarily apply to Amazon, because I'm sure they've got plenty of people smart enough to figure this out. But when you've got the small mom and pop that's doing e-commerce and sending stuff out of state, they've got to try to figure out sales tax for other jurisdictions and calculating that. And that's the type of burden that a lot of politicians are leery of placing on folks. I can tell you here in Texas, it's sort of an interesting issue. There is a distribution center up in the northern part of the state. I'm down here in Houston, and I say we as if I'm part of the government, but I'm not. The government has sent Amazon a $269 million bill for unpaid sales tax. And of course, Amazon has fought that and has threatened to pull out of the distribution center. And with our governor throwing his hat into the ring in the Republican primary, Governor Perry, it'll be interesting to see how this plays out as presidential politics plays out, especially with the Republican no tax stance, while at the same time both states, counties, and the federal government all needing to find revenue somewhere. And with all of the e-commerce out there, that is one place to get some.
Although, you kind of making, sorry, Denise, I was just going to say there's an interesting point, though, because when you talk about tax burden, one of the things that's often left out of the discussion is that most of these states that are looking to require Amazon to make the collections have a use tax anyway, which would basically, the use tax is the equivalent of the sales tax, but the burden's on the consumer. And so what Amazon is actually asking the state to do is not to get rid of the sales tax necessarily, but to shift the burden to the consumer. And, when you talk about mom and pop shops as being inconvenienced, I actually wrote a post years ago when this started all becoming kind of a big deal about the fact that iTunes, I didn't get charged sales tax on my iTunes. And when I went to look to see how hard it would be for me to file a use tax return in this Commonwealth of Pennsylvania, I was astonished at how difficult it was. And because you have to pay by month, it's crazy. And, when you're talking about a 99-cent purchase, it really does shift the burden to the consumer. So I think that, I understand Texas and the GOP's position about not wanting to, raise taxes. But I think we have to keep in mind that no one's raising taxes. They're just shifting the burden of collections.
Yeah, that's an excellent point. We got a good question in IRC from Webby there, Kelly, who would like to have the whole concept of nexus defined a little better and why internet businesses should be taxed, but other businesses without a nexus in a particular state would not be?
It's actually a really great question, and it's kind of tricky to define, which is exactly why people are fighting about it right now. Traditionally, nexus was considered physical presence. That was for eons. Again, blew me by mail. A couple of the big court cases on this issue focused on the idea of physical presence. And the idea was that if I am, let's say, a soda shop in Pennsylvania, and I'm not located in New Jersey, I'm not doing business in New Jersey, then I shouldn't be subject to their jurisdiction for purposes of taxation. That's kind of the gist of it. So in terms of sales tax, if a company didn't have a brick and mortar store in a particular state, they didn't have to collect sales tax in that state. So let's say my soda shop expands and I have 5 of them, and now they're in New Jersey, Pennsylvania, and Delaware. But I don't have one in North Carolina, but maybe I do business in North Carolina, but I don't have a shop there. I don't have a presence for purposes of sales tax, so I wouldn't have to collect sales tax in North Carolina for that reason. So that's kind of the gist of what nexus is. It's whether or not you have basically jurisdiction for purposes of collecting tax. And again, it used to be very, very clear that if you had a brick and mortar store, or if you had some kind of very tangible tie to the state, then you were subject to jurisdiction because of the nexus. For, again, jurisdiction in the tax sense, not necessarily in other legal senses. And so where that's gotten tricky is, and where the affiliates come into play, is a lot of the traditional case law took the position that even if you didn't have a store, let's say you had a salesperson, and again, that was back in the day when you had door-to-door salespeople, and they would come by and try to sell you something. If you're the soda shop again, and I go to another state and I have a salesman, does that salesman create a nexus? Is that now a tie to the state that would subject me to jurisdiction? And the general answer has been yes. That in fact, having an active sales force became a jurisdictional issue for purposes of nexus. And then it gets even trickier because many states are taking the position that an affiliate, such as Amazon has, is kind of like their door-to-door salesman. That now, because they're promoting or benefiting or profiting from the company in some way, then they have dragged the company into the state. And so that's where, again, it gets tricky, because Amazon took the position of no, just because somebody has a link on their site isn't the same as having a store there. And so that's why, I don't know if that cleared that up a little bit, but that's why there's a confusion about what nexus means on the online sense versus what it means traditionally.
Yeah, I think it did. Thanks. The other, so where this stands now is it seems like Amazon may be on the brink. It's all rumor and speculation at this point, but they have a deadline of working something out with the state of California where Amazon backs off on trying to get the California law repealed, and the state holds the taxes, doesn't collect the taxes for a year, holds off on enforcing the law for a year. Is that pretty much your understanding? Right.
They're going to hold off collecting the taxes they were supposed to start in 2012. And so they would not collect the tax. And then Amazon would stop trying to put it on the ballot, because they were trying to put a referendum on the ballot in California to basically eliminate the law completely. And they had spent about $5 million to garner 500,000 signatures. So, they were willing to put some money out there to get that passed. And I think the state realized that they couldn't compete with those kind of dollars. But it's,
right.
It's interesting.
California's election system is so crazy to begin with. You know, we go back and forth about the laws that the legislature passes all the time, because all you have to do is put a ballot initiative on and throw enough money behind it, and you can pretty much get the voting public behind you. So you saw this with the gay marriage issue in California, going back and forth, back and forth. So I could well envision that kind of thing happening on this sort of dispute.
Right, but I think it's an odd concession for Amazon to make, though, because even though I understand they clearly stand to benefit, and there's some speculation that they're pushing the moratorium for one of two reasons. One is either that they're going to try to push a federal sales tax through, which, quite frankly, will never happen. Well, I shouldn't say never. It's not going to happen in a year. Or that they're going to leave California at the end of the year. I don't know that I think either one of those things are going to happen. I think that, companies like to make a lot of noise about leaving states because they don't get the tax breaks they want. And Amazon did that in South Carolina. And South Carolina said, then, don't let the door hit you on your way out. I mean, they're not going to change their law for Amazon. And I think a lot of states are taking that position. So I'm not really sure where Amazon is going to go. I'm sure there's a state somewhere that's willing to change their laws. But so far, it hasn't been North Carolina, hasn't been South Carolina, hasn't been Texas. It's California for a year. It's not going to be New York. So it'll be interesting to see what happens. And I also think that Amazon only agreeing to a 1-year moratorium because they actually were reportedly pushing for 2, I think is an odd, maybe almost tacit admission that maybe their legal position isn't as strong as they think it is, or that public opinion has changed.
Yeah, it sounds that way to me, especially when you get people like Tim O'Reilly writing, okay, so it's been long enough and you guys have gotten enough incentives and you're doing just fine. Evan, what do you think about that and about the whole federal law that might normalize all of this were it to ever happen?
I think what Tim O'Reilly has to say about all this is really interesting. And not only is what he has to say interesting, but if we are to try to surmise why he is saying it, and it's a little bit mysterious if you examine it from a certain perspective. And here's what I mean. The big thrust of what he says in his post on Google Plus there is think of the dramatic effect that Amazon's getting out of paying the sales tax will have on the local economy. He uses the example of, well-known bookstores being shuttered, 7 years later, no other retail space taking over that. And as if to say that is the fault of the advent of and expanded almost omnipresence now of e-commerce, that's the reason that local economies are suffering. I find that conclusion, in as much as it's, he's trying to explicitly make that, a bit hard to believe. I think there are plenty of reasons why local economies are suffering that could very well have to do with federal taxation in the first place. But that's, far from the actual issue here. It would seem that, well, first of all, I guess I'm not qualified to speak on as to what effect, some kind of federal efforts to normalize all of this would do. I'll leave that to the other smart tax people in the world to handle with that. But I guess the main gist of the concern that I see on all of this and the real difficult issue to handle and to tease out is the effect and the place and the role that the local economy, the mom and pop shops should play in all this. There's a bit of an irony here, or a bit of a paradox, and Travis mentioned this really early on in his comments. What about the mom and pop shops who are trying to do e-commerce? I mean, if you look at it, isn't that kind of a strange position to be taking here, because we have lamented the decline of the mom and pop shop for years because of things like, Walmart coming in and the mom and pop bookshops being displaced by Barnes and Noble and Borders and Amazon.com. So isn't it a strange position that we're now making assertions like that? I mean, not to delegitimate it, Travis. I think it's a perfectly valid concern to raise. What it illuminates for us is, I guess the mom and pop shops lose out no matter what. Isn't that right? They're going to lose out because of the monolithic benefits to major e-commerce retailers like Amazon.com being tax-free, and they're also going to lose out if indeed there is a system whereby e-commerce is taxed. How are we supposed to resolve all of that? I haven't the faintest idea, but that seems to me the real difficult issue of how to foster and really, encourage the growth of local organic commerce, if you will, at the local level.
Well, I have some thoughts on that, but let's kick it to Travis to respond directly.
Sure. Evan makes a good point when he talks about that. And, you got to think about the mom and pop on the other side, too, in that, if I'm looking for a book, do I want to save the 8% or whatever the sales tax is and get it off of Amazon a few days later? Or is that enough of an incentive to get me online versus going down the street to my independent bookseller? For a $20 book, probably not. You start talking thousands of dollars for a really nice TV, it might be worth thinking about trying to get it tax-free and sent. And not that I've done that. I'm not going to admit that I have not paid the taxes that I owe. When it comes to taxes, I avoid paying the maximum, more than I'm supposed to, just like I avoid reading the tax code as well. I'm like Evan in that I don't practice tax law for a reason, and leave it to people who are smarter than me and, quite frankly, have a better attention span than me, because when it comes to the tax code, that's what it takes. So I'm not going to answer that, have necessarily a legal position or the be-all, end-all for this issue. But the mom and pops, I think, are getting it both ways, in that it will really complicate things for them when they're doing business online. But at the same time, at their bricks and mortar location, there are probably people who the 8%, 9% sales tax is enough to convince them to get something online rather than go down the street and get it in person.
Yeah, I think that probably goes without saying. And just to play devil's advocate with you a bit, Evan, it seems to me that the mom and pops, they do get it a couple of different ways, but they get some benefits too. If you're driven out of business because either because of Amazon or some big box store is taking all your physical customers, you're still able to go online, I think, and reach an audience that, you never would before. You just look at Etsy. Those people are a lot of those people are literally individuals working out of their homes, the smallest of small businesses. And what I worry about, I'm so glad that there's that kind of opportunity, and there's this safety valve of somewhere economically to go as things shift around and more transactions move online. But I think back to Kelly's comment about how the individual accounts for the sales tax that they owe that the online business is not collecting. If we're going to put it on the online businesses to collect those taxes, then I think it has to be straightforward and not an overweening burden for someone on Etsy, for example, to do that. And, Kelly, how far away do you think we are from living in that kind of utopia?
Oh, I think we're miles from that. I think that, part of the reason that I still have a job is because the tax code is, it's getting more complicated, not less. And I'm actually all for simplifying things. I spend a lot of time helping people sort things out. And quite frankly, it's the least enjoyable part of my job. But just to go back to one of the points that were made earlier about mom and pop stores, I'm a small law firm, so I get it. I understand. In my city, there are 14 in Philadelphia. There are 14 different kinds of taxes that small businesses are responsible for filing and paying. So I get it. But I want to stress that and I know that some of these comments are also on the chat, the same kind of vibe, but which is that I think that as this develops, I think that it will become easier for small businesses like mom and pops to find the technology to make to charge the sales tax. I think that there was a time, you look at cash registers, you look at credit card payments, all of those things are getting easier because of technological advances. Somewhere someone's building an app that's going to figure out the sales tax issue for small stores. Do I think that it's fair to shift the burden to them? I'm not saying that, but I think we also have to think realistically that if Amazon comes up with and that they have it because Barnes & Noble, which is a competitor of theirs, does collect sales tax because they have physical stores in most states, and so they do collect sales tax. And I just got something the other day from Barnes & Noble in my store, in my state, and online, and they do charge sales tax. If they have that technology, it's going to eventually trickle down. Is it going to be easy? Is it going to be cheap? I'm not going to say that that's true, but I think that Amazon wants to paint this picture of mom and pop being somewhere in a corner with a green spreadsheet trying to figure out the sales tax for every purchase and looking at a tax table, and I just don't think that that's the case. And actually I can confidently say that that's not the case because at our firm we represent some internet companies that deal with this very issue.
Well, I can think of one internet company that I hope someone is listening to the show, either Jack Dorsey or someone else from Square, because it seems like a real good fit for the kind of thing that they're doing to try and solve this problem as well with their software and apps. So just a thought there. We've covered taxes. Let's talk about death, but let's talk about it in a more upbeat way if we can. That is that things are not going well for Right Haven. So that seems to me an upbeat topic. Things haven't been going well for Right Haven for a long time, but right now their contract with the Denver Post seems in jeopardy. Evan, you want to fill us in there?
Sure. I mean, this is just one indication out of several that Right Haven's campaign of going after infringement is nearing its end. Just quickly to summarize, I'm sure most people are familiar with Right Haven, but what they do is they get by purported assignment the copyright in journalistic materials, newspaper articles, and stuff like that, and they're going after mostly small independent publishers like bloggers who have posted copies of these news articles. So there was a newspaper in Las Vegas, and then also the Denver Post signed up with Right Haven and assigned a lot of its rights over to Right Haven. And so Right Haven has suffered several legal setbacks. The biggest one is the court in Las Vegas finding that it didn't have standing to pursue these copyright infringement litigation claims. We've talked about this in a previous episode of TWiL because of some problematic language and the nature of the purported assignment of that copyright. Right Haven didn't have the rights to actually be pursuing these things. So that's really put it behind the 8 ball from a legal standpoint for being able to pursue these claims. They're just kind of hemorrhaging, being hit with having to pay the other side's attorney's fees in a couple of situations. They've laid off their in-house counsel, or their in-house counsel has left for whatever reason, whether he was laid off or left of his own will. And now the Denver Post, we just learned in a story yesterday that it's not going to renew its agreement with Right Haven. So what this said another way, Right Haven has lost one of its big clients in this situation. All kinds of negative PR came out of Right Haven stuff, and what's featured in this Denver Post article is, or it's actually about the Denver Post. It's on Westward, which is kind of like a little independent newspaper there in Denver. Great stuff. I remember from when I lived in Denver, but it's talking about the Denver Post. When Right Haven went after this kid named Brian Hill, who had a mild form of autism. I think he lived in North Carolina. Yeah, that's what it says. And so just the most sympathetic kind of defendant you could imagine. He and his mother both have certain disabilities that made them live on just disability payments. This just did not look good for Right Haven, going around picking on people like this and indicating that they could extract settlement fees from these disabilities check that these folks were receiving. So Right Haven made a number of missteps along the way, which is going to be inevitable if you're going to run a lawsuit mill like that. We can remember how bad the RIAA was in its 5-year plus campaign going after individual file shares, filing lawsuits against pretty sympathetic defendants. So all of these things kind of coming together are increasing the weight that Right Haven is feeling. probably by this time next year, Right Haven and all of its efforts at this copyright trolling, which it's been characterized, will probably be some historical artifact that we'll refer to as having happened in the past. So that's what's happening with Right Haven.
Well, thank you. I love how Michael Roberts concludes his Westward piece here. He says, although the Right Haven CEO is speaking optimistically about the company's future, with this contract not being renewed, it's hard to imagine another major publishing company providing a bridge under which this troll will be able to hide. Travis, any thoughts about Right Haven and this development?
Sure. I think I share Evan's unspoken lack of sympathy for our discussion of death in this context, but it has changed some of what what I've done and what I have advised clients. It used to be, on a close call, I would just advise them, go ahead and put it up on a close call. Maybe fair use, maybe parody. Some other exceptions to certain copyright violations. And if it's a close call, put it up there, because in reality, what's the worst that can happen? You'll get a DMCA takedown notice. You'll get a cease and desist letter. You take it down. At that point, if it's if you don't feel that strongly about it, and you move on with your life. And then these copyright trolls came along, and so we had to take a closer look at some of these. And for these smaller independents running websites that are barely surviving, it became a problem. And so it's interesting in that it's changed the advice, because normally when these folks don't have much money anyway, and if I'm representing somebody who owns the copyright, who does have enough money to hire lawyers and do that, the unspoken rule is you don't sue poor people, because I can get you a pretty piece of paper, but I'm not going to get you any money. So what would be the point in suing somebody in that regard? But that seemed to go all out the window, and the business sense and common sense and sort of just business reasonableness went out the window when these came. When this started happening. And so it did change some of the way that we had to look at these for these smaller independent websites that were taking hard stances and using portions of newspapers to talk about controversial items on the web. But it'll be interesting, and I hope Evan's right in that this might be a relic of the past, and it goes away, and people get back to more common sense and more just being reasonable.
Kelly, I know that copyright infringement and Right Haven may not be your first area of interest, but I wanted to give you the chance to weigh in here if you've been following along with these guys, if you have any thoughts.
Actually, I haven't been following it a whole lot beyond what I've been reading on the web, so I actually don't have a lot to add, sorry.
That's all right. Just wanted to give you the opportunity. We've got the opportunity here in the U.S. The president is going to have the opportunity to sign a new patent law, a patent reform law, into law very soon. The Senate passed the, what are we calling it? America Invents Act. And that's going to go to the president's desk shortly, and we're going to look at that in more detail. But first, I want to thank our sponsor for this episode of This Week in Law, and that is Netflix. Netflix streams thousands of TV episodes and movies directly to you instantly, as you no doubt know by now. They're really the way that our family loves to consume entertainment these days, right there along with any of the other options that we have in the house is the Netflix option. And it always has something amazing to entertain us. You can watch on your Mac or your PC or your iPad. You can watch on your iPhone and lots of Android phones too. If you have a gaming console, your Xbox 360, your PS3, your Nintendo Wii, you can use that to watch right on your living room TV. And if you're not a gamer, you can watch on that same TV with an Apple TV or a Roku box, which is a fabulous little device in its own right. Those are all inexpensive options, and even more inexpensive and convenient. You're probably going to have a DVD player in your house, and lots of the Blu-ray players ship with Netflix software built right in. So one way or another, you're going to have access to all of this wonderful instant content. And because you've got access on so many different devices, it's super convenient that you can start watching a movie or show on one device and then finish on another. So thanks, Netflix, for that wonderful bit of insight. And you can begin watching any of those thousands of movies anytime you want, whenever you want, all for one monthly fee. So you can enjoy all your Netflix to your heart's content, and should it somehow not work out for you, you can cancel anytime. But there's no risk to you involved at all, because you can try it today for 30 days for free if you're not already a subscriber. You can go to netflix.com/twit. Be sure to use that URL when you sign up for your free trial. That helps us out a bit here at This Week in Tech. We thank Netflix for their support of the network and of This Week in Law, and we hope you enjoy watching instantly with Netflix. So America Invents has been passed by the Senate. It changes a lot of financial things with the patent system. I know that people hear the words patent reform and hope that the big issues that people have with patents will be resolved. You know, that patents will be looked at more closely, and patents that shouldn't be granted or overbroad or don't take into account properly the prior art won't be granted. And this particular act doesn't go directly to those hot topics, but it does change some things around in how the fees for filing patent applications are going to be used and allocated. The fact that the USPTO, under this proposed legislation, will get to charge set fees for applications. It will keep more of that money itself. So people speculate that sort of one of the effects of it will that if the USPTO has more money and resources, then things will function better there toward the other points I was just mentioning. So I don't think anybody would argue that this is necessarily a bad thing for folks who want more sweeping patent reform, you know, baby steps toward more sweeping patent reform, and this is a good step along those lines. Some people are nonplussed that the proposed legislation will help bigger parties more than it will smaller parties, so there's some debate about that. But it seems set to pass, and so I guess that's something that's a good thing. Evan, have you been taking a look at this, and are you happy that we finally have some move toward patent reform?
It's always good to be taking the step in this direction, and I suppose that what might be underlying some of the criticisms with it, I mean, the big one being, the fact that money can still go other places beside the patent office. The patent office will be able to keep most of the money that it gets from fees, which should have the intended effect of that is to speed up the application process by giving more resources to the patent office so that it can get patent applications through faster, which is going to, in turn, stimulate innovation and create more jobs and all of that stuff. So, I mean, that's a good thing. I suppose that underlying the criticism with all this is to the extent that this didn't go far enough, it's almost like we all know that major patent reform doesn't come around all that often, so it may be another 50 years before we really get around to revisiting this stuff again, or at least a long while. So to me, that's my sense of kind of the disappointment that some people may feel in that this didn't go far enough, is because this is not like it's going to be a top priority next year if there's already been this much emphasis given to it this year. The thing that I find most intriguing about all of the patent reform is the fundamental way that it changed, the rights of priority of inventors. No longer is it now a first to invent system in the United States, but it's a first to file, which really will change the dynamic of the patent application process and the effect that prior art and the researching of that prior art, the effects that will have, which is a very detailed kind of complicated terrain left, to the province of the patent lawyers. But, that is a very fundamental change in the way that we approach patent rights and granting priority to the inventor in these things, which incidentally brings us more in line with the rest of the world being a first to file basis. So it's exciting to see these things. It's always difficult to evaluate in a vacuum what the real practical effect on the economic bottom line will be because of all these things, but certainly seems to be a good step in one direction that hopefully will create jobs. And by the way, did you hear about the drinking game that people were doing for President Obama's speech, before Congress? Every time he says the word jobs, you're supposed to drink. So that's,
oh, God.
Yeah. A lot of people hung over.
Many a lit up individual as a result of that speech.
Yeah.
Let's see, Travis, what do you think about the new patent reform bill and whether it goes far enough?
Obviously it doesn't go far enough, but it is a sort of what's been said as a baby step. I've talked to developers and especially small app developers and other folks, and this is the number one concern that they have when they're creating something and they put, and I'm going to grossly overgeneralize this because I like reviewing patents about as much as I like reviewing the tax code. But when they design something and decide to put a box at the top right of the app that starts the game or keeps a high score, well, lo and behold, somebody 10 years ago put a patent on that, and they didn't know it. And what they've been telling me is that they actually do, for their business models, when going forward basis, they have it built in to lose 1 penny per license or 2 pennies per license going forward to take account for when somebody shows up with this random patent. But the problem they're facing is if they've been out for a year and had this product going for a while, they don't have it in their business models to make up for some of the past damages. And that's really what is concerning them. I will say this. The good news is that I've seen this more and more on the traditional media. There was a big thing on NPR about this issue, and I think it was either the New York Times or the Wall Street Journal did a couple stories about this. Obviously, with the way the economy is and everything else going on in Washington and weather and everything else, it's not going to take the lead on the nightly news. But the fact that the mainstream media is talking about this more and more is encouraging that while this is one step, there may be some more in the future.
Yeah, let's talk about that NPR piece for a while, because people have been sending it to me for weeks, and we haven't actually discussed it on the show yet. It was called When Patents Attack, and it was on This American Life, and I believe they did a shorter version of it on All Things Considered. We have it in the show notes. Again, those are at delicious.com/thisweekinlaw/128 if you haven't checked it out yet. It's an incredible in-depth piece on intellectual ventures, which was founded by former Microsoft CTO Nathan Myhrvold, and is sort of classically cited as an example of a patent trolling company, and gives you some real in-depth understanding of what intellectual ventures does and how it buys up patents and then resells them. And as you read along through the story, you find out they follow along with one patent that was resold, and they tried to figure out something about the buyer of that patent and what they were going to do with it. Of course, they went out. It was a very broad patent that would have enabled them to sue literally thousands of people. They did bring some lawsuits, and NPR tried to run down, okay, so who is this entity that's suing and who has an interest in this entity? And it turns out a couple of interesting things. First of all, the entity was just located at some very small lockbox kind of corridor of empty offices with mail slots in Texas. And that the Eastern District of Texas is a very advantageous place to bring patent infringement lawsuits, or so the perception is. So it's located there, so it can easily bring those suits. There's nobody there, but learning the address was an interesting thing. They figured out from that Intellectual Ventures was actually keeping a back-end interest in some of the patents that it would sell. So if they made more money off the lawsuits, then Intellectual Ventures would get a kickback. And they also, interestingly, note at the end of the piece that Lotus, which we've talked about on the show before, going after iOS developers, that they are officed in this very same sort of anonymous, unoccupied suite. In fact, they share the very same address down to the suite number of the company that is profiled in this NPR piece. So if you haven't yet checked out When Patents Attack, it's a very interesting read. Kelly, did you take a look at this, and do you have any take on the new patent reform legislation or on patent trolling?
Well, I've been tangentially following the patent reform because I think that there's a lot of similarities between efforts to reform the patent law and efforts to reform the tax law, which are both that they're just enormous undertakings that I think you used the word baby steps, and there's a lot of, I think, movement to want to change things, but I'm not sure that the folks that are making the laws are in the best position to understand and make those changes. And where I practice, there are two attorneys that have been following these matters very closely, and so they've definitely come up in discussions, and we've drawn a lot of parallels between them because it is something that when you look at the reform movement, and I hear the folks in my office complaining, and then I see what's going on. It does seem like enough to kind of keep people quiet for a little while, but no real change. And I agree with the comment about, I think people are disappointed because this was the big chance. It was kind of what people were focusing on as maybe this is our fix, and it's not. So, again, it'll be interesting to see whether it kind of stagnates for a bit. I guess that there's going to be case law that drives the change and not legislation. I don't know. But it is interesting as somebody outside just listening in on conversations in the office to kind of follow.
Yeah, absolutely. Evan, did you look at this NPR piece, and did you find it as fascinating as I did?
Yeah, I just gave me new, inspiration to save up enough money to buy that big cookbook that that 6-volume. We've talked about that before. That huge 6-volume cookbook that Nathan, I can't ever remember his last name. got. So, yeah. That's all I want because it's very scientific. That's what I got out of this piece.
Yes, he's an interesting individual. I actually, at listeners' suggestions, and because why not? Why wouldn't you just take a flyer on it? I actually contacted them to see if he or some representative of Intellectual Ventures might ever want to come on the show. We'd be thrilled to have them and have the chance to talk to them. So who knows? That's one of those ones you throw into the ether and see if anything ever comes back.
Yeah, I would love to hear Matt and Macari have a conversation with somebody from there. That would be a really interesting show. It
would be. All right, so we've talked about the promised death taxes and patent trolling. The other thing I found really interesting this week is a lot of people just sort of sounding off, using the internet as their platform to express their views and make sure that people have their side of the story. One such person is, gosh, I'm going to butcher his last name, Henry Juskowitz, possibly. He's the CEO of Gibson Guitars, and they are being gone after about, from the federal government. They had an investigation, sort of a raid from the DOJ about some of the rare woods that they use in making the guitars. And there are claims that perhaps they have woods on hand or using woods that they're not supposed to be having there. They are quick to say, and Henry, the CEO, is quick to say that there's no smuggling, there's no illegality. This was, a crock, and he's very much litigating their side of things in public via his Posterous and his Twitter. And I just always think it's interesting when social media is used in that way. It's so new from the way that legal disputes played themselves out, back when I went to law school and for the many years now that I practiced, getting people to take their story directly to the public in this way, circumventing all forms of press release and filter. I always think is an interesting thing. Evan, did you look at this at all?
Yes, I did, and you make a great point about how this is a good use for social media to get this issue out there, because one can really empathize with the Gibson company's frustration with all of this huge, bureaucratic inertia that's holding this up. They've been raided a couple times by the feds. It's a complicated statutory scheme. It's all based ostensibly on environmental concerns, so that, kind of makes it inherently frustrating at some point, because, how do you translate the regulation to the real benefit? That's always very difficult with environmental issues. So it's really innovative how the CEO here is going out and using these things. I mean, his writing is really entertaining. He's always up for writing up a good rant. So it's good for him. Points for him for being innovative and getting the message out into a situation otherwise where it would be a very opaque kind of thing going on here.
Right. Travis, you write the eMedia Law Insider blog. Does your practice extend to folks taking their stories public using the various electronic forums available to them?
It does, and it's always a thorny issue. I mean, you can look at several examples, the BP disaster being one where they were relatively quiet for a while, and they caught a lot of flack for that, as opposed to just simply coming out and trying to control the message. And then another example I like to use is I don't know how long it's been, a little more than a year now, where the JetBlue flight attendant kind of went off and yelled at somebody and ran out of the airplane. And a lot of the social media folks were very critical of JetBlue, because JetBlue is kind of a young, hip, quirky company that does normally take advantage of social media. But of course, they had lawyers whispering in their ears, and I'm sure those lawyers were saying, be careful, because if they made light of the situation themselves, that's the first, imagine the CEO of JetBlue in front of Congress, and one of the congressmen reads a tweet, making light of this situation, and the congressman having to answer, does JetBlue take, security and safety of aircraft seriously, in light of, what their normal type of message would have been, a quirky and fun type of thing on Twitter or social media. So it's always a difficult issue. We kind of play it on a case-by-case basis, and it just depends on whether you have the opportunity to control the message and whether you have the right people to do it.
I would just follow up on, sorry, Denise.
Sorry, go ahead.
I would follow up on something that Travis said. Is my bigger concern would be that there weren't lawyers whispering in the ears of the folks who are posting, because I think part of the allure of Twitter is that it's so immediate, and I love Twitter. But one of the drawbacks is that, the internet is forever. And I know that things can be scrubbed, but pretty much it's forever. And, 140 characters isn't always enough to state your message in the way that we lawyers want to see it stated sometimes. And so my concern is when you have these companies, which I do think that reacting is generally better than not reacting, because, silence is interpreted a lot of different ways and often not positively when it comes to, big stories like this. But my bigger concern is folks who will take to Twitter, take to Facebook to express their position without talking to an attorney. And again, I'm speaking about companies that, generally have counsel on hand, not saying that everybody who ever tweets needs to run and get an attorney. But I think that part of the problem is, you don't want someone maybe admitting something that's going to be used against you later. And you have to, sadly, you have to think that way, especially when you're talking about something like a JetBlue case, or where there might actually be some, not just folks who are reacting to something that's happening to someone else like Gibson, but where there might be actual real consequences from a litigation. So I think that social media is definitely changing the game. I think you have to be careful, though.
Okay, so I think that's a great backdrop to talk about TechCrunch and what is going on there this week. There's a comic that ran a few weeks ago that I've wanted to bring up on the show because it just resonated with me. It's the XKCD comic, a wonderful web comic. I'm sure folks are fans. And the crux of this particular one was being careful about what you write, because you never know, a future employer might read it. And then the person who's the recipient of that warning says, "When did we forget our dreams?" And he goes off on this really long, passionate tirade about how, I'm not going to regulate my life to have other people's expectations just dictate everything that I do. And I don't have all the answers. I don't know how to jolt myself into seeing what each moment could become. But I do know one thing: the solution doesn't involve watering down my every little idea and creative impulse for the sake of someday easing my fit into a mold. It doesn't involve tempering my life to better fit someone else's expectations. It doesn't involve constantly holding back for fear of shaking things up. This is very important, so I want to say it as clearly as I can. And he gives a very graphic sort of, statement at the end that we can't utter here on TWiL. So it's just, the great declaration of I am me, and I'm going to be who I am online, and I'm going to have integrity and so on. And that seems to be what every single person, the writers over at TechCrunch, from M.G. Siegler to Paul Carr and Mike Arrington himself, are doing as they try and sort out what's going on with AOL. And, I don't think they themselves really know what's going on with AOL at this point, but there does seem to be some sort of separation happening there. AOL going back on the promise when it acquired TechCrunch to give them complete editorial control over what they do. That seems to be coming to an end, and the writers there really want Mike Arrington to be able to appoint the editor who will run that site, and if he can't, apparently they're all going to walk. But the interesting thing has been their transparency in putting that all into TechCrunch in post after post. Okay, here's what we know now, and here are my very blunt feelings on the topic. They've all been saying. And I just think it's amazing to see the employees of a business expressing themselves so transparently and forthrightly, and as this has all been unfolding. So I threw that in for discussion today because, talk about using the internet as a sounding board. There has been a lot of that going on at TechCrunch this week. Travis, have you looked at this, and has it surprised you at all?
I'm a little new to this story, but no, it doesn't surprise me with regard to this type of company. Now, when you're dealing with creative folks who are taking advantage of social media and sort of living on the social media world, you got to be prepared to deal with them when you anger them and when you upset them, because they're not going to be afraid. And especially, these days, people are changing jobs more often, and so it's not a matter of, if they lose their job at TechCrunch, there'll be a place for them down the street somewhere to do the same. So it didn't surprise me that often. And again, I will admit I'm new to this story, but it did seem a little odd. I'm a former journalist myself, and one of the things I read in there, and maybe I'm just not up to date on it, is about whether or not there were disclosures made by TechCrunch when they were covering certain stories about what investments they may have had in some of these stories and products that they were discussing. And so on one end, you've got the employees being very transparent and very forthcoming about their personal feelings about what's going inside the business with them. And meanwhile, you've got, an interesting discussion anyway for a journalism ethics class, discussing what type of disclosures should have been made. And then, after reading that and then reading Evan's posts on his blog about the NLRB, is this concerted activity that these employees are now protected from any retribution by their bosses for expressing themselves, would be also an interesting discussion that Evan is more well-versed in than I am, probably.
Yeah, as far as the disclosure issues regarding investments concerning TechCrunch and Mike Arrington in particular, that has been, I think, the subject of journalism classes for several years now. Mike's never made any secret of what he does, and he thinks that he discloses everything just fine, and it doesn't, if it's impacting their content at all, people are aware and they can make their own judgments about what they about the quality and caliber of the reporting, and go from there. So, Evan, tell us about the NLRB and what you think about these comments and how they might be treated.
Well, just one quick point about Mike Arrington. The question about disclosures is only truly exciting if you're dealing with a Palm Pre. You may ask, see if anybody remembers, Leo and the discussion of that from June 2009. But in any event, the NLRB and Facebook, this was the National Labor Relations Board is an administrative body in Washington, D.C. that enforces provisions of the National Labor Relations Act, certain unfair employment practice or labor practices undertaken by employers. So they have jurisdiction to fine companies and order companies to do things when they are violating certain parts of the law. Among those things that they can enforce is they can go after companies who are prohibiting employees from doing certain protected activities. One example is acting in concerted activities, concerted efforts to deal with the conditions of the workplace, for example. So this issue has made its way into our consciousness a couple of times with some things that the National Labor Relations Board has said, actions that have been brought before it. The general counsel of the NLRB is like the one in the position of the plaintiff here. It's not the employees who are the ones who bring these actions, but it's an agent within the NLRB who brings these actions before the board and the respondent would be the employer. So there have been actions brought against employers who are going after their who have terminated their employees for saying certain negative things about the company on Facebook. There was one involving an ambulance company late in 2010, and we got a decision from the NLRB on September 2nd in a case called Hispanics United. This was out east somewhere, the NLRB. The issue was whether or not this nonprofit organization in, I think it was Buffalo, New York, wrongfully terminated 5 employees for commenting on a Facebook status update that one of the employees had made. Long story short, 5 employees were engaged in a conversation in the public area of Facebook, or at least the non-private area of Facebook. Somebody was saying, was concerned about another employee going and ratting them out at management or making complaints about their job performance to management. So these employees were talking about their concerns that this other employee was going to go to management with these issues, and this all happened on a Saturday morning. Everybody was doing this on their home computers, and they weren't supposed to be at work that day. On Monday morning, or maybe Tuesday, they all got fired, and the NLRB brought an action against the employer, saying that this was a violation of the National Labor Relations Act. You employer wrongfully were trying to prohibit them from engaging in this concerted activity. So the National Labor Relations Board decided in favor of the employees and ordered that the employer has to give them their jobs back, issue back pay, and stop having this kind of policy in place whereby you terminate employees for having these kinds of discussions on Facebook. Now, this is all really an interesting case, and the point I made in my blog post from this past week about it was, it's the reason that we're talking about it is because it involved Facebook. But if you actually read the decision from the NLRB, the decision itself and the rationale behind the decision has essentially nothing to do with the fact that it was on Facebook. There's nothing special about social media that made the character of the types of communications among these workers special. It, from what I know about these types of actions, this looked like a pretty straightforward analysis of this kind of issue. But here we are talking about it because it had to deal with Facebook, and this is the first actual decision by the administrative law judge at the NLRB the actual decision that dealt with these facts, a termination, a firing that had to do with communications through social media. So that's what makes it special. But if you look at it closely, there's not a whole lot special to it that is made special because it was on social media. But it's worth noting nonetheless. So that's what's going on in that front.
Well, thanks for that update. It sounds to me like the TechCrunch folks are far more likely to walk out than actually get fired. And so maybe the NLRB isn't going to be any help to them. But I think it's fascinating that, they have their position and their audience are such that if they do walk out, they have opportunities that I think other employees might envy just because of their high-profile ability to communicate online. I think that these people will certainly land on their feet if they do indeed walk out, and I think that AOL had better keep an eye on that property, because without its heart and soul, it's just not going to be the same thing. So, anywho, well, that's the end of the drama, I think, for the week. Except for, sorry, go ahead.
Oh,
Kelly,
I just wanted to chime in. Yeah, just real quickly. I just wanted to say, with regard to TechCrunch, that I was actually, I wrote for AOL. And I was there when the buyout happened with HuffPo. And without talking more drama, I will just say it's really interesting to have kind of watched this evolve, because there have been a lot of folks that have kind of focused in on Arrington, and I think it's not so much that he's changed as the culture at AOL has changed with the buyout. So going back to something that Evan said about how the Facebook case is getting a lot of press just because it happened to be on Facebook. I think that this is getting a lot of press just because of the scale of readership at TechCrunch, but I think it's something that's going on all over AOL with the management change, and I think that's something that a lot of companies deal with, and I think that social media is just making these kinds of episodes and dramas play out in a really public way. So, I think it's anytime you have a buyout or a merger, people are going to be unhappy because things have changed. I just think that we're just watching it happen because of the media. So I just wanted to weigh in, because I know there's been a lot of criticisms of the way that it's been handled, but I don't know that all of the criticisms are just.
Yeah, I appreciate that, and I couldn't agree with you more that we're living in an interesting world where these things, that used to happen behind closed doors, don't anymore. All right, well, I think we're going to go ahead and get into our ending segment here with our tip and resource of the week. Before we get to that, I do want to give a shout out to the students of John White over at Clayton State University in Morrow, Georgia. They actually use TWiL for extra credit. So I think that's just phenomenal, except for, sorry that we're giving you, I guess it's extra credit, so it's optional. I was thinking, gosh, TWiL for homework, that sounds like such a chore. But they get to choose whether they're going to listen to the podcast and write a 3-page paper summarizing the show's topics and explaining the significance of the covered topics to their lives. So that's just fabulous. Thanks a lot, John Weiss and your students, for listening to the show. We hope you guys enjoy it. Our tip of the week, I guess, is aimed at lawyers, and it's also sort of an explanation for people who are not lawyers. I'm frequently asked why more lawyers don't know more about gaming. And the answer to that question, I think, gets a graphic explanation from one particular lawyer who was disciplined and suspended because his gaming just sort of took over his life and practice. And instead of handling the various obligations he'd signed up for as a lawyer, he was off fragging whatever he needed to. So fragging and interrogatories apparently don't mix at all. And that is, I think, the reason why you don't see too many lawyers who are terribly up to speed on games and gaming, because I think we just get sucked into these things, as happened to this poor Pennsylvania attorney. Were you following along with this, Kelly? Was this news in your neck of the woods?
Oh, it was definitely, it made the reporters, sure.
Yeah.
It's an interesting defense, because there's been a lot of talk about addiction and what addiction means, and was he really addicted to gaming? And it's interesting, because one of the comments that have been made is that one of the ways to be forgiven by the disciplinary board, at least in Pennsylvania, and I believe in California, because I think Ronnie Deutsch made a similar comment at her press conference, is that if you can blame your behavior on something over which you swear you had no control over, sometimes it's considered okay. And it was an interesting argument. I don't know a lot of gamers who are attorneys just because of the time crunch. I think, you have to figure out where to put your time, and he chose to put his time outside the practice of law. And he characterized it as an addiction, and whether or not you believe that is another issue. I will say that a lot of my colleagues did not have the level of sympathy that he may have garnered outside of the practice of law. I don't know how it was received by his clients. Clearly, they wouldn't be happy with him, but a lot of my colleagues didn't consider his story to be necessarily very sympathetic.
All right. Thanks for that. Hey, Evan, before we get off and do our resource of the week, which is going to take the form of a video that we'll play for you, that we can't really end our tax show without mentioning the story that you put in IRC about simplifying the way that some small business entrepreneurs can do their taxes. And this is in Germany. You want to let us know what happened there?
Yeah, I'm glad you shook me out of my stupor. I was busy, I was in Second Life or something just then. There is a machine. It's an article on a site called PSFK. I hadn't seen this before, but it looks like a site that has interesting stuff on it. And it's on the screen now if you're watching the video. Street sex meters for tax-paying sex workers. How do you like that headline? It's kind of hard to say. But there's this machine. It's built by Siemens. Imagine that. A $12,000 machine that... Why are you guys laughing? I don't know. Long story short, here's what it is. It's a machine that's on the streets of Germany, and prostitution, I guess, is legal there. That's news to me. But you go and you buy a ticket for €6, and that makes you compliant with all of the local tax-paying obligations. So if you're a sex worker in Germany, you buy your ticket, and you don't get in trouble for not paying your taxes while you're applying your trade. So seems really innovative solution to a problem that is one of the big justifications, I guess, for keeping prostitution illegal here. How do you tax this stuff? So maybe this is the salvation for our civilized way of life. After all, this machine here that collects taxes for sex workers.
Wow.
Well, I'll chime in real quickly and say that it won't happen in the U.S., not because the technology isn't very clever, because it is, but they actually have tried to tax prostitution in Nevada. The prostitutes want it taxed. And the opposition has been from folks who believe, much as with the marijuana debate in California, that taxing it adds legitimacy, and they're trying to keep it as portrayed as immoral and as illegitimate as possible. So I don't know that we'll be taxing. Yeah, exactly. I don't think we'll be taxing hookers anytime soon here in the States.
Yeah, Toad Sloth in IRC makes a good point. Shouldn't the John being the one paying the tax? Why would we tax the sex worker? Isn't it? Should be more like a sales tax.
That's right. And then we're right back to the problem of how you account for all the various taxes you owe as an individual.
And what state you come from.
Right.
They're treating it more as like an income or a business privilege tax, which is kind of funny, to think about the privilege of being a hooker.
Right. Okay, so our resource of the week is this great video. Should you ever need to show anyone a graphic demonstration of how the length of copyright works in the United States, Colin Gray has cobbled together this video. And I just want to go ahead and let it roll and let you guys see a bit of it.
Is a story you'd love to remake, but since J.K. Rowling published The Sorcerer's Stone in the United States in 1998, it still has copyright protection, so you can't use it. Instead, you need to find something from a long time ago. For example, George Lucas released Star Wars: A New Hope in 1977. That's more than 28 years ago, so great, get filming. Alas, no. While Star Wars should have lost copyright protection in 2005, it's actually copyrighted until 95 years after publication, not 28. So you can't use it unless Lucas lets you. Why does his copyright last for ages? Well, as long as there has been copyright, there have been authors arguing that it's too short. And perhaps they're right. How's a poor guy like Lucas supposed to turn a profit in the mere 28 years between 1977 and 2005? After all, there was only the theatrical release of A New Hope, and the theatrical re-release in 1978, and again in 1979, and 1981, and 1982, and then there was the 1982 VHS and Betamax releases, the 1984 broadcast television release, the 1985 Laserdisc release, the 1989 widescreen Laserdisc release, the 1990 VHS re-release, the 1992 widescreen VHS release, the 1993 Laserdisc re-release, the 1995 VHS re-release, the 1997 special edition theatrical release, Han Shot First You Bastard, the 1997 VHS special edition release, and the 2004 DVD release. And now you, dear filmmaker, come along and want to make your own version of Star Wars A New Hope? For shame. That's like stealing food right out of George Lucas's mouth. 4 times, Congress has agreed with authors that the length of copyright is too short to turn a profit and has so extended it. First in 1831 from 28 years to 42 years, then again in 1909 to 56 years, in 1976 to the lifetime of the author plus 50 years, and in 1998 to the lifetime of the author plus 70 years. That's a great deal for authors who have already made stuff, but does it really help society get more books and movies? It's hard to imagine, for example, that Edgar Rice Burroughs started writing A Princess of Mars and Tarzan in 1911 because the copyright laws had just been extended and would not have done so otherwise. Or that J.K. Rowling, while living on benefits in Scotland, was busy doing the math and wouldn't have written Harry Potter if the copyright protection was just for her whole life and not an additional 7 decades thereafter. Because exactly who needs incentives after they're dead? Dead is the point at which literally no incentives in the whole universe can compel you to write one more screenplay. Because you're dead. Dead, 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 dead. If you're the kind of person who is only motivated by plans that unravel after...
So I promised you death, taxes, and patent reform. There we go. You're dead, 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 and have no further need for incentives. I just love that video. It's from Colin Gray. There's much, much more of it, and you can find it on YouTube, and it is his rant and explanation of copyright's lengthy term. So thank you, Colin, for that. And thank you to our wonderful panel for joining us today on This Week in Law. We've had Travis Crabtree from the E-Media Law Journal. The E-Media Law Insider. So we really appreciate your joining us, Travis, and we hope that everything continues to go great with you. Where can folks find you when you're not on the show?
You can check out my blog, emedialaw.com, and the website for the law firm is lrmlaw.com. That's Looper Rita McGraw here in Houston, Texas.
Great. You're on the Twitter, too, I believe. Are you Travis Crabtree over there?
Yes, at Travis Crabtree on Twitter, and there's an eMedia Law Facebook page as well.
Wonderful. Thanks again for joining us today.
Thank you.
Kelly, wonderful to have you on the show. Thank you for getting in touch. I understand your husband is a fan.
Oh, yeah. He's the reason that I know, well, you and I have met, obviously, at Blog Her, but he's the reason that I know about the podcast. He's quite a devout listener.
That's wonderful. We love your writing at Forbes, and we really appreciate your shedding light on these complicated internet taxation issues today.
Thanks much for having me. I had fun.
All right. And where can we find you other than your Forbes blog?
Well, I'm on the Twitter as well, at TaxGirl, and also on Facebook.com at TaxGirl. And I practice as well in Philadelphia at Erblaw, ERBLAW.
Great. Thanks again. We'll talk to you soon, I hope.
Thanks.
And Evan, great always to have you on the show. Had such a fun discussion today.
It's great always to be on the show. This was a fun one, wasn't it?
Yeah, it was. You know, who knew that death taxes and patent reform and, well, of course, German prostitution's is always an interesting topic. So,
yeah, next time that comes up, let's cover that one first. So, always good.
Always lead with porn, as we say.
Yes. Thanks for having me on. Really had a good time.
Yes, me too. And of course, you can find Evan at internetcases.com, and he is Internet Cases on Twitter. You can find TWiL at twit.tv/TWiL. We record the show every Friday live at 11 o'clock Pacific Time, 1800 UTC. We love to have you join us live and jump into the IRC with us. Give us your feedback during the show at irc.twit.tv. Off the show, when we're not recording live, you can find us at that site that I mentioned, twit.tv/TWiL, and of course on iTunes and wherever you like to consume your online video media. Roku has a Twit channel, and there are all kinds of ways to tune in. So we hope that you do. If you're looking for our discussion points, we post those on Delicious episode by episode This is episode 128, and the account is This Week in Law on Delicious. And we have a Facebook page for the show at facebook.com/thisweekinlaw. You can get in touch with me either by emailing Denise at twit.tv, or you can get in touch with me on Twitter. I'm D. Howell there. I'm Denise Howell on Google+. And I monitor all those things quite regularly, so love to hear from you between the shows. And until next time, this has been This Week in Law. Thanks so much for joining us. Take care.